look at 31C, which is essentially a power in the arsenal of the state to acquire, to completely take away, then, my lord, Article 39B looks like a bulldozer. But Article 39B, your lordships have always felt, is a control on the power of the government. Provide context to my submission that please do not look at 39B from the point of view of 31C. There is another much more primary, much more primal, much more important way to look at Article 39B from the point of view of Article 31C. We are not going to get a distorted view. One reason, of course, is what my learned friend said, that at the beginning of the Constitution, 31C was not there. So, your lordships, my lord, if your lordships were to look, there is, of course, a link between 31C and 39B. But if that is going to be the starting point of inquiry,
39B cannot be interpreted from the lens of 31C.
And, my lord, this is relevant because all the nationalization cases that your lordships have dealt with in the past, those are all very extreme cases where there's a complete taking of certain establishments, industries, etc. And then in that context, my lord, a justification is given by the state and your lordships will approve it. But at the dawn of the Constitution, all these provisions were not there. And like my learned friend pointed out, Article 31, Article 19(1)(f) were coexisting with Article 39B. So, my lord, if that is the situation, and the second point, my lord, would be that Article 39B has never been construed as a vesting of legislative power. There's a 5-judge bench decision of your lordship saying very clearly that if at all we're talking about acquisition or requisition, etc., there are very clear entries in the Constitution that power is always there. So in the context of acquisition and requisition, entry 42 of list 3 covers the area. In Ishwari Khetan's case, my lord, your lordship said that the state doesn't really have to bother too much subject to the definitions of industry, etc. The power is always there. And my lord, even independent of that, the power of eminent domain is a concept which is so very well known in this Constitution that there is no doubt that if the government of the day wants to take over any property whatsoever, there is nothing really fettering them except Part 3 legislative competence and not all the usual restrictions. So 39B would therefore not be seen as the source for the government or the parliament to do certain things. There is no doubt about this throughout the interpretations of your lordships. So if
directive principle, which is fundamental in the governance of the country,
I'm grateful.
It is a principle.
It is a principle. It is the purpose.
But it's of power.
That's right. Which is why, my lord, the Chief Justice said that if any of the laws, forget only 39B, my lord, any directive principle of state policy, if it is sought to be given effect to, of course, it's a reasonable thing to do, provided always the nexus, etc., are clearly laid out. So, my lord, we also cannot put it to so high that private property is off bounds at all points of time. That cannot be, my lord. But for that, 39B interpretation is not going to be the starting point or even the ending point. 39B is a purpose. For achieving that purpose, there are other powers that the government always has had. Exercise those powers and then see, my lord, whether 39B is one of the objectives that is sought to be fulfilled. And why stop only with 39B? There are other directive principles also. So, my lord, in this context, how exactly are we supposed to look at a directive principle of state policy? What is the importance to be given to it? What is the primacy to be given to it? And what happens when a directive principle of state policy collides with a fundamental right? And now there is a wealth of jurisprudence of your lordships on this issue that something like a directive principle or a fundamental right part, they should never be so construed as to conflict with each other. They should be construed harmoniously. And I can do no better, my lord, than to place my proposition in Minerva Mills. My lord, the Chief Justice Chandrachud had very categorically placed the contours of the debate. And if we look at Article 39 from that perspective, then not much of the apprehension that the government would like us to believe that if there is an interference with 39B, we will lose a lot of ability to do certain things. Not all that will be washed away. Provide context to my submission that please do not look at 39B from the point of view of 31C. There is another much more primary, much more primal, much more important way to look at it. 31C, which is essentially a power in the arsenal of the state to acquire, to completely take away. Then, my lord, Article 39B looks like a bulldozer. But Article 39B, your lordships have always felt, is a control on the power of the government. In the natural resources case, the presidential reference, my lord, your lordships have expressly said so, that 39B is a limitation on power. But if you look at it from 31C, then it looks like it is a very formidable power. But if if the matter is looked at in according to paragraph 56 and 57, and Lord, these observations have also been reaffirmed by the Rhine judges bench in Coelho's case. I'll place that paragraph before your lordship. So there is no doubt, my lord, that this balance between part 3 and part 4 is a part of the basic structure. If that is so, my lord, then Article 31C should not be definitive or determinative of the way in which 39B is to be construed. Firstly. Secondly, my lord, Article 31C, your lordships are very well aware, is a very peculiar article. It is in part 3 of the Constitution dealing with fundamental rights, but actually it is a Trojan horse. It takes away the fundamental rights. So how can that provision be part of a balancing equation between part 3 and part 4? It will lead to a distorted vision. Which is why, my lord, Mr. Sen's argument in Sanjeev Koko is very clear that when you look at 39B, distribution presupposes something to distribute. That something to distribute, there is no fetter on the power of the government. Why the apprehension is coming is because 31C provides an immunity against the challenge on Article 14 and 19, which the government of the day does not want to answer, of any day. And therefore, my lord, from this perspective, if we look at 39B, my lord, we will come to a wrong result. So with that, my lord, may I immediately take your lordships to what is the balancing that Article 39 in fact talks about. We'll keep the fundamental rights on one side, but 39B, my lord, in my respectful submission, is in continuation and part of, paired with, coupled with Article 38. One cannot be read without the other. And my lord, the use of the word in particular in Article 39, to some extent, my lord, helps my argument. But more importantly, the manner in which Justice Chandrachud has, the Honorable the Chief Justice had interpreted it. 38 provides the bedrock and 39 provides a further mechanism to give effect to it. My lord, please see Article 38 before we get into Article 39. Now, my lord, Article 37, lordships have seen that they are not enforceable, but my lord, we have come too far away. They are very important directive principles of state policy. My lord, we should not dilute the importance of that. Question is, to what extent does it justify a certain exercise of power? And if an immunity is sought to be claimed, my lord, whether your lordships will permit it or not. So Article 38, my lord, the language of Article 38, my lord, there were two amendments. The state shall strive to promote the welfare of the people by securing and protecting, as effectively as it may, a social order in which justice, social, economic, and political shall inform all institutions of national life. Then, Lord, subclause 2. The state shall in particular strive to minimize the inequalities in income and endeavor to eliminate inequalities in status, facilities, and opportunities, not only among individuals, but also amongst groups of people residing in different areas or engaged in different vocations. Lord, here I may just emphasize.
Came by the 44th Amendment.
That's right, Lord. Absolutely. Now, my lord, what is even the 44th Amendment focusing on? It is equality of status, facilities, and opportunity. It is not an equality of result. If I may explain this point. Every person, every citizen should have an equal opportunity to lead a better life. Provision of that opportunity is not the guarantee of an equality of result. Everybody who works hard is not going to succeed in life. Everybody who's got money may not get a certain commodity, whether he likes it or not. There is no equality of result which is guaranteed by Article 38. Now, my lord, this is very vital to understand Article 39.
There is one important
yes,
difference, as Chief was pointing out yesterday. 38 is this big, 39 is smaller.
I'm obliged.
Difference is the 38 is not protected by 31 capital C.
That's right.
As they would like us to read capital 31.
That's right. But
That's the major difference.
yes, Lord, and that is exactly the canvas of this debate, that the parliament or the state legislatures want to provide.
39 only. But 39, 38 will not get that protection.
My respectful submission is that 39 is in species with 38. So
39 is illustrative of 38.
I'm obliged, my lord. So that becomes very clear immediately in Article 39. The state shall in particular direct its policy towards securing. Now, my lord, if there was no umbilical cord between these two, this word in particular, this phrase in particular is an unnecessary addition here, because my lord, it is perhaps a non-statable proposition that parliament or legislature can make a law which goes contrary to what is written in Article 39. There will be no law, my lord, which will be passed to
Particular indicates that the state may follow certain other policy goals. But these have been emphasized by the Constitution.
I am obliged. And the larger policy goals are in 38. Now, Lord, this is where, my Lord, this is Julia's question.
Beyond 38. 38 also may not be. 38
My Lord,
is broad. It says that social order in which justice, social, economic, and political shall inform all the institutions of the national life.
my Lord, here, the argument is that if equality of status, equality of facility, equality of opportunity is the goal, it is not equality of result, then you are empowering the dignity of people by saying that I will create the circumstances in which you can do your best, but beyond that, don't expect a result from the government. And that Article 39B, my Lord, is exactly towards that the material resources of the community are so distributed so as to subserve the common good. So if your lordships were to interpret this in a manner that enhances the dignity of individuals, then, my Lord, the meaning would be that acquisition or taking away a right. Lord, just as a footnote here, I am aggrieved by the rent control measures. There, my Lord, it is not my property that is being taken away. There is a restriction put on my right to charge a rent. That restriction says that you can't charge more than the standard rent. Now, my Lord, the Chief Justice had mentioned that a right to a property, like for instance, the pen or this book, this is my right. But, my Lord, the Hoffeldian analysis says that my right to property is not just my right to this thing. Along with it, there are a number of other rights which are built into it. My right to preclude somebody else from it, my right to charge, the right to capital, my right to charge for this particular thing. These are all the various rights, and they're already protected to a significant extent by the Contract Act or the Transfer of Property Act. There is nothing very spectacularly unique about, my Lord, my house rent stipulation. It is there in every lease, it is there in every contract. And the question is, my Lord, that when your lordships are interpreting a statute which is taking away a particular species of rights, how does that get construed in the context of acquisition, non-starter? How does it get construed in the context of taking away a right? There has to be, my Lord, some connection between what is being taken away, to whom is it being given, and in what manner is it being given. And that is the answer to my Lord's question, that Article 39B in my respectful submission actually only talks about how the government of the day can give effect to anything that it wants to do, any policy that it wants to do. So, my Lord, throughout the 80s, 70s, 90s, your lordships have seen a spate of nationalization judgments. In the past decade or so, my Lord, hardly any nationalization of a very big scale happens. Post 1995, your lordships have seen there's more and more private-public partnership. Now, the way in which the government should be able to do some things in a given socio-economic condition cannot be circumscribed by either the Constitution or by your lordships. The free play in the joint that the government may need in today's condition may not require nationalization, may require public-private partnership. Now, this creates a number of sub-issues. To whom are we going to give these resources? How are we going to give these resources? So Article 39B talks about how the ownership and control of material resources of the community, such as airwaves, such as gas allocations, such as private forests, such as mines and minerals. These are all, nobody can claim immunity from those being taken away on the basis of some fundamental right to property. But once they belong to the state, in whatever way, how they are going to be given is Article 39B. And, my Lord, if it should not result in crony capitalism, is Article 39C. So the free play in the joint in Article 39B, which is how the parliament or the state wants to give effect to a particular policy by bringing in, my Lord, for instance, auctions. Your lordships will deal with that issue. In the natural resources, the issue was clearly that, should we go for auction, or are there other ways in which the government can give away what are these material resources of the community? Your lordship said it's a case by case, very broad kind of a canvas on which the state has free play. You cannot prescribe only auction as the way, because that would be fettering it. Now, my Lord, your lordships considered Article 39B in the natural resources reference. So Article 39B, my Lord, is only this. It is only a leeway given to the government to do a thing in a particular way. Article 39C says that when you do that, it should not result in concentration of wealth, crony capitalism. That's all that Article 39B does. Anything more being read into Article 39B, my Lord, is a burden which it doesn't need to carry. And my Lord, the final respectful submission is only this, that please see the effect in this case. In the Malpe judgment, your lordships categorically held the predecessor act, 1947 act, to be violative of Article 14. There was no plea taken at that time that Article 31C is applicable. It could have been taken, they did not. Your lordships found that Article 14 is violated. The state made a concession that yes, we are actually going to redraw the law and we'll take into account this judgment, obviously, and also the model law which is being discussed with the housing ministers. What they did thereafter was they came out with the 99 law. Nothing but old wine in a new bottle, the same degree of toxicity which was found unfit to be consumed by your lordships. And then, please see the mischief here. When the matter came up, the state now says, we are taking protection of Article 31C. And that is recorded in the order, my lord, where there is another reference even in my writ petition. So, my lord, the point is, if 31A is going to be a shield against 14 and 19, even in cases like this, then, my lord, 39B is really in need of, my lord, insulation from the attacks of 31C. That's all.